This meeting is being recorded.
What's up, Jordan? How are you?
Hi, I can't hear you.
Can you hear me now? Should be able to hear me.
I can't hear you, Sean. Wait, hold on. Is it my bad?
Probably because I think my audio.
Whoops. Hi. My volume was down.
I was like, I'm pretty sure mine is on there. Let's see.
How are you?
I'm good. Busy as hell. I can't complain.
Oh, that's good. I am just making sure that everybody has the Zoom link, and we're gonna get started in a few minutes.
Cool.
So I figured that you were probably just gonna talk about whatever you wanted to talk about, and then we do like Q&A at the end.
Yeah, I was gonna think because all of them are leasing, right?
Well, okay, so a lot of the people that are in our Facebook group, they also do residential.
Okay. So
So
what I may do then is just talk a little bit about contracts, sort of like a high level version of it, and then some of the issues I see from a legal perspective, and then I can do some leasing side of it too, if you want to do
yeah,
it.
I think a lot of people want to know about like the question we've talked about, like, is it beneficial to set up an LLC as a real estate agent? I think a lot of people also, a big thing in the leasing industry is that like some of these apartments will just refuse, like they just won't pay us. Like
Oh,
it
yeah.
could go like 8 months without being paid. So I know a big thing people are like, well, can we sue the apartment complexes? Like, how does that work? Like,
I can talk about that too.
yeah, that's like a thing. And then I think also, everybody's all concerned about like the settlement stuff. So I think people are kind of starting to ask questions like, how is that going to affect like the leasing industry?
Yeah.
Yeah, and then I think other people will have their own questions, but definitely the people that are in the group also do residential. So you can still
Okay.
talk to those people as well.
Do you think it's worth going through contract stuff, or you think I should just focus on LLCs and the commission issues?
I would maybe start there and
Okay.
then see if anybody, and then like talk about the leasing, the LLCs, that type of stuff, and then ask if people have questions, and then see how long it goes, and then it might naturally just flow into residential questions too.
Okay. That works.
So, but definitely, okay, so it's noon. So how do you want me to introduce you? Because like obviously you're one of the owners of Tiago Title. I know you do a lot of stuff.
You can just, I mean, if you want me to, you can just say this, Sean, and I can just sort of give my little 2 cents
Okay.
if that's easier.
Yes, that is. Okay, cool. I'm gonna
Yeah.
start letting people on. Okay. Hello, hello.
I recognize some names on here.
I know you know Kelly.
Hey.
Yeah.
All righty. Kelly, did you message our 2 different group chats telling them that we're starting?
I will do that.
Okay, I put it on our Facebook group as well. Hi, everybody that is on the call. Hopefully you can hear me and see me. Feel free to either keep your cameras off or turn it on. And you also are welcome to use the chat to ask questions when question time is here, or you could use through your microphone. But we're going to go ahead and get started because I know that Sean is super busy, but Sean is our amazing real estate attorney that has helped us with all of our businesses for School of Apartment Locating and the Rise Agency. So we wanted to have him come on today to answer some legal questions. So I'm going to let Sean just take it away.
What's up? Hey, Jordan, Kelly. Thanks for both of you guys for having me. So I will, a little background about myself. So I am a real estate corporate and title attorney. I own a real estate corporate and title law firm. I also own a title company. While title company is licensed in Texas, I practice law in Texas and Colorado. So with that said, I think one of the things that we would talk about today that Jordan and Kelly thought would be somewhat beneficial for you guys is to entity formation, LLCs. How does that work as far as real estate agents are concerned? Is it beneficial to create an LLC? And you guys stop me at any point in time if you have any questions whatsoever. I'll focus on LLC. I'll talk about NAR if you guys want to talk about that, and then I can talk about anything legal related if you guys have questions on that too. So one of the first things that I think it's important to talk about for agents is that in January of 2024, you as a real estate agent can now get paid through an LLC or an S corporation. And so one of the questions I often get is there a benefit for a real estate agent, not a broker, because brokers were always LLCs or S corps or corporations, C corporations. So this is not, this is for the agent themselves. Is there a benefit to doing that? And in my opinion, there always has been a benefit to doing it from a liability perspective. And so one of the great tools that we have in Texas is an LLC. And for those that don't know, it's a limited liability company. A limited liability company allows the owners of that company itself to be insulated from liability. Why would that come into play as a real estate agent? You might be thinking, well, when the hell am I ever going to get sued? And believe it or not, agents get sued all the time. And one of the reasons for that is a lot of times it's bogus. A lot of times it's not right. It's crap. It's BS lawsuits. But nonetheless, as an agent, if I form an LLC, what I'm doing is protecting myself personally. So let's say I own I'm a real estate agent. I have my homestead property. I maybe own a couple other properties. I've got bank accounts. I do well, right? So I've got assets, and I'm not incorporated. I'm not an LLC. And you take part in a transaction with a buyer or seller, whatever your client may be, or even in a lease situation. You represent a tenant or you represent a landlord. And when your client or another customer gets really upset and decides to sue you for whatever reason, let's say maybe you represent a landlord and there was somebody that the tenant tripped and died on the property. Now you've got a wrongful death lawsuit against the landlord, but plaintiff's attorneys generally don't just sue one person. They sue everybody. So they sue the landlord, they sue you as the agent, they sue your brokerage. And then let's say that there's a judgment, maybe there's some sort of gross negligence that a court decides that the agent was at fault, and there's no LLC formed, and they pop you for a $5 million judgment, right? That's problematic for a lot of reasons. If I get hit personally with a $5 million judgment, that judgment creditor, whoever won that judgment, can go after all of my assets, with the exception of a homestead property, can go after all of my assets to collect. But if you have an LLC, that's one of the benefits to having an LLC is the shielding of liability. So if as an agent, I was operating under an LLC, the LLC protects me personally. So if in that same hypothetical that we just gave, if somebody sues and they sue your LLC as an agent and they get a judgment against your LLC, they can't come after you personally, right? And so an LLC is one of the many ways that not just real estate agents, but people in general, brokers, business owners, investors, landlords, all of us that have frankly, any assets whatsoever, usually use an LLC because it shields us personally from liability. And it used to be a pain in the ass, excuse my language. It used to be a pain to get paid to an LLC. You had to be registered by TREC to get paid. But as of January of 2024, you don't have to be. And so now you can receive compensation through your brokerage. So you can get paid as an LLC. Now, that's the liability protection. I'm not a CPA, so let me say this. Let me say that first. But there are also tax benefits. There can be tax benefits to LLCs. And Jordan and Kelly and I have had this conversation where certain taxes after you reach a threshold of revenue can be then distributed to you free without having to pay taxes. So without having to pay federal tax, Social Security tax, withholding tax. And so there are tax benefits to that too, depending on the amount of money or revenue that you're generating as a real estate agent. And so I'm a huge proponent of real estate agents having their business as an LLC to shield themselves personally. We're in a very sue-happy society these days. People sue over anything, the most bogus reasons. The barrier to entry for lawsuits is just not hard. And with commission issues and things like that, and all this public spotlight, so to speak, on real estate agents, there's going to be, in my opinion, there's going to be an increase in the number of lawsuits that happens against real estate agents for whatever ridiculous reasons it may be. So I think now is the time for real estate agents more than ever to insulate yourself and create an LLC to shield yourself from that personal liability. You just don't want to find yourself in a situation where you are on the opposite end of a lawsuit, and then you have to call me and say, I need you to defend me in this lawsuit, or you have to submit it to your E&O carrier and say, I just got sued. You just don't want to find yourself in that position. So that's a good segue into talking about the NAR commission lawsuits and what does that look like. I think some of you guys on this call today do both leasing and sales. I've talked ad nauseum about the NAR settlement, the NAR litigation. I do it every month. And not to do it, this is not a shameless plug by any means, but if you're on social media, you can follow me on social media. I give a little, every day I do legal videos. Let me just put this on here for you guys real quick. This is my Instagram and my TikTok. So you can see little videos I've done on this very thing. But one of the things to talk about with the NAR settlement or litigation is it's hotly contested as of right now. There are objections that are being filed to the settlement itself in the NAR litigation, and that's generally how federal litigation works. If I have a proposed settlement of an antitrust lawsuit, which is effectively what this is, you have an opportunity, or parties have an opportunity to intervene or file what we call statements of interest in the litigation itself. And then basically saying, hey, we object to this, or we don't object to this, or we object to it for these reasons, or we don't object to it, we agree to it. And one of the key factors in that is the Department of Justice. And for those that don't know, real estate commissions have been attacked for 40 years. I mean, people have been coming after real estate agents for commissions, trying to knock down whatever, the commission amounts that you guys get paid. Even the Attorney General of the United States, like 2 months ago, came out and said that, closing costs are too high, and the one place that they need to cut is real estate commissions. So it's always been attacked, and that probably always will be the case. And the reason I bring that up is that the Department of Justice, which is, as you guys know, the Attorney General of the U.S. is the enforcement arm of the Department of Justice. And the Department of Justice is intervening in the litigation, the National Association of Realtors litigation, in my opinion, because I think that they're afraid that NAR did this sort of workaround, because as you guys know, NAR only deals with properties that are put into the MLS, multiple listing services, where there's anything we use the term realtor. So offers of compensation, unilateral offers of compensation have now been prohibited, or will be effectively. I think now it's August that they will be prohibited. The Department of Justice is likely going to take a position that they don't want this just to apply to properties that are in the MLS or multiple listing services. They want it to apply to consumers and commissions regardless. Because remember, as it stands right now, all commissions are negotiable. So whether if the property is not in the MLS, I can go negotiate as a seller or a buyer's agent or a landlord, or a landlord's agent or a tenant's agent. I can negotiate in whatever way I want as it relates to commission. And so I think the Department of Justice is going to try to stop that. The reason I bring that up to you guys is so that everybody understands all of this sort of fear. I hate the phrase fear mongering, but that's kind of what it is. All this stuff that's out there about everyone, commissions are going to get attacked on the sales and the purchases, and agents are really going to suffer in this business, and they're not going to be able to make any money anymore, and commissions are going to go away. I just don't buy any of that. I just really don't. I don't buy it on the purchase sales. I certainly don't buy it on the lease, the land leasing side. I think on the leasing side, you're pretty well protected. I'm not too worried about them because they're not really trying to go after commissions on the leasing side. So I'm not too worried about it. On the purchase sales side or the residential side, I'm not that worried about it either, because if you can demonstrate your value as a real estate agent, people are going to pay you what you're worth, right? I mean, if I'm able to, it's the same thing with an attorney, right? I mean, when people come to me every day and they're wanting to hire me, I still have to demonstrate my value to them. I can't just go, hey, I'm the best, you got to hire me, right? That's just not how it works. I got to show them why I'm the best. And the same thing holds true for you guys as real estate agents. You just have to demonstrate the value. And you have to be super conscious now, though, of the paperwork that you're doing, certainly on the sales side. You have to be conscious of documentation. You got to document everything. You need to treat every client, and this goes for leasing too. You should treat every client treat them like an attorney. Treat them like what attorneys do. And I'll tell you what attorneys do. Every communication I have with the client, you can rest assured if that communication has been on the phone. The minute that conversation ends, I'm going to send them a summary via email of what we talked about. Allow this conversation to summarize allow this email to summarize our communication earlier today regarding boom, 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 right? I'm listing out all of the stuff we talked about. So it's really important on the sales side because I do think agents, there's going to be an increase in the number of litigation against agents, but it matters on the leasing side too. So, and I hope that you guys are doing that as a best practice. Every communication, every text message that you have, whether you're on the landlord side, whether you're on the tenant side, I don't care. You need to document the communications. You need to document in writing the verbal communications that you're having with your client. If I'm representing the tenant, okay, and I'm communicating with the landlord about compensation to me is the tenants or prospective tenants commission, I want to summarize communications I've had with the landlord, right? I want to write back, hey, allow this to summarize our conversation earlier today that you're offering X number of dollars payment for the lease, right? So everything, you need to treat everything, leasing, sale, buy, you need to treat it as though like an attorney does. Summarize everything, document everything, put everything in writing. It's just, you have to do it. I just don't see any way around that. And if you guys have more questions about commission, we can certainly talk about real estate commissions in the NAR. I just wanted to give sort of a bird's eye version of that. I already brought up commissions because this has been a big deal and it's always been an issue. And I get hired to do this stuff all the time where landlords just are refusing to pay the commission effectively to you as the tenants, to you as the tenant's agent. And I try to take I try to tell brokers, or I do tell brokers, to try to take the conservative approach, to try to be agreeable, to try to be nice. But it's not uncommon for landlords to just refuse to pay or to just ghost you and to not pay tenants, and to have to go track them down and to constantly be following up. And so my rule of thumb is usually 90 days. I know that seems like a long time, but follow up every other week, follow up every week. And hey, if the commission was earned, which presumably it was, if there's a tenant that's been placed in the property, but follow up. And then at some point in time, if the commission is not paid, or if the landlord balks at it, despite the written agreement, you're going to have to, and that's sort of when I come into play, or when I get hired a lot, is, at 30 days, 60 days, 90 days, these landlords are not paying. It usually takes a little bit of a shove, right, by an attorney like me to collect commissions for you guys. And I don't mind doing that at all, because frankly, it just pisses me off when landlords don't pay. But they have a tendency to do that. You have it, and as tenant reps or tenant agents, a large portion of your business, certainly for the brokers like Jordan and Kelly, is just tracking money down and following up and sending invoices. I don't have a problem doing that. You have to follow up with that. And that goes in connection to, it ties to what I talked about earlier, which is document everything in writing. Because what I've seen happen a lot of in this market are landlords going, no. We didn't agree on paying you whatever, $3,000. It was going to be one month's rent, or $1,000. And that's not what they put online. It's not what they advertise. It's not what the agreement says. But you have to document all these conversations that you're having. Certainly, if you're on the tenant side, all these conversations you're having with these landlords. And anytime they try to modify what's already been agreed to as far as the leasing commission, you got to call them on it. And it just has to be that way. because oftentimes landlords will say, well, you called me and yeah, okay, we posted this, but that's not really what we were agreeing to. We were going to agree to pay 1 month's rent, not two. So keep documentation of that. What are you guys, Jordan, what are you guys seeing what are landlords paying these days? I don't even know.
So in the apartment industry, it kind of depends on if you're working with like the luxury market or if you're working more like in the like it depends on which market you're in. I would say that like people are typically paying like 100% in the luxury market. Our team doesn't really do residential leases, but I know when we were doing it, you're lucky if you get paid 50%, but
Yeah.
usually it's like 35%.
Yeah.
So I think that was going to lead me into like, at what point, like obviously hiring somebody like you, an attorney, to like help try to like fight for commission. How much would it be worth like to actually fight for a commission? I have a $2,000 outstanding commission.
Yeah. That's a good question. That's a tough one for me to answer because my hourly rate's $500 an hour, right? So I mean, it's probably not worth it. But having said that, I do a lot of favors for real estate agents because I care a lot about you guys. I mean, so you sometimes will do stuff for free. A lot of times I do it for free. I'll give it one go. If I have to take somebody to court, that's a different ball game, right? Because that's a lot of time for me. But sending a letter, I mean, I don't mind sending a quick email or letter for an agent on the house. Like that, I've always done that for 15 years. So I don't have a problem doing that. But I mean, I agree to your point. Like, if it's $2,000, most people aren't probably going to get free legal advice or free legal work. So let's just assume you don't have that. Over $2,000, you could just pursue it yourself because Justice of the Peace Court, the jurisdictional limits are $20,000. So you can go to Justice of the Peace Court, file a lawsuit yourself, and go litigate it in JP court. To have an attorney go to JP court for you is just for $2,000. I mean, it's just absolutely not financially worth it because I mean, the average, even a baby lawyer, I mean, I've been an attorney 15 years, so my rate tends to be a little bit higher, but like a baby lawyer is probably $200 an hour or $150 an hour. So it means 20 hours of work you've already blown through. It. So I would say for a lot of people, for a lot of agents and brokers, they just pursue it themselves in JP court. And it's not JP court's not hard. I mean, you can just jump online for most Justice of the Peace Courts and file your petition yourself. And it's a breach of contract. That's all it is. It's just simply that. It's a breach of contract cause of action because it didn't pay you. But what does that look like? So you sue them for breach of contract. You get a judgment in JP court. What do you do with that judgment? Well, now you have to go try to collect on that judgment, which means does the landlord, the person that you got the judgment against, do they have any assets to collect against? Yeah, a big apartment complex does. Mom and pop that have one house that they're renting out that were supposed to pay you that now doesn't, they probably don't have a whole lot of assets to pay it. So, there's a practical consideration. As a principal person, people need to pay their debts, and so I have no problem with suing people. But from a practical standpoint, suing somebody over $2,000, probably doesn't make a whole lot of sense, and it sure as hell doesn't make sense to hire an attorney over $2,000.
Yeah,
just absolutely not. I mean, it just doesn't. 5,000, 10,000. If you can get attorney's fees awarded to you by the court, then possibly. But $1,000, $2,000, $3,000, it just doesn't make sense.
well, I think in the leasing industry, at least, so I know that whenever you're helping with a residential piece, you get paid whenever it funds and the house is closed. So, but with doing apartment locating, which I think a lot of people do in our group, our biggest challenge is we don't ever really know when we're going to get paid because the apartments can pay us whenever. So although it's great if they pay us within 30 to 60 days or 30 to 90 days, I guess it's good. It's a good idea in my mind to now understand that maybe we could send a letter, like not necessarily you send a letter, but just send a letter saying, hey, it's been 6 months. You haven't paid us. You said you were going to pay us within 60 days. Just trying to figure out, I think agents struggle a lot with that with apartment locating. And a lot of agents don't ever want to get into apartment locating because they know that they're going to have to fight tooth and nail just to get paid. And it's not like that in residential.
Yeah, I mean, I agree with you 100%. I mean, when residential, as you know, when it closes, and people get paid. But what I would suggest doing, even in the apartment locating world, and it's pretty easy to do, like especially for those that have my contact info, which I'll put in here. Um, a lot of times, like on your follow up, and I have a broker that does this. She'll like on the 90th day, she'll like send an email to or follow up with the land or the apartment company, and then she'll be like, I'm adding my attorney, and then she'll just copy my law firm email on there, and then miraculously within like a week they get paid, right?
Yeah.
And it's not even so much that like I'm sending a letter, because I'm not. It's just her. It's just the thought of she's saying, hey, look, this is now on the 90th day. This is my 9th follow up. Therefore, I'm including my attorney on this email for a further communication. Then she just copies my email, and it's at Sean@scjwlaw.com. And right, so for a lot of apartment complexes, they just go, F that. Like I'm not.
Yeah.
What? And because what I think they expect, they don't expect an attorney to be involved over $1,000 or $2,000 or $3,000. They just don't expect it. And I think apartment complexes in general, I think they bank on that. I think that they know that the barrier to entry for attorneys is high because of the cost. And so I think they just go, oh, screw this. Like, we're just not going to pay. Or we'll just postpone it. We'll just delay until they actually take it serious, which usually includes getting an attorney involved. So for those that are on the chat, we can see the chat. You can pass out my information too.
Yes, we'll definitely share your info, but put it in the chat. And those of you guys who aren't following Sean on Instagram, he puts out really, really great informative videos that I think are helpful. Like, they answer a lot of questions that I think most of us are like, hey, I don't want to hire an attorney just to ask these 5 questions, but Sean's putting the info out there for free. So definitely follow him. I did want to ask also, so as far as we talked a bit about earlier about setting up as an LLC and why that's important, all of that. So obviously, people can set themselves up as an LLC, but is that a service that you do as well? Like, you can set up people's business structures?
Yeah. Yeah, I'm glad you brought that up. I can. What I always tell, maybe people accuse, maybe I have too much integrity for being an attorney, but I tell people all the time that you can pay me to set up your LLC, but what I try to do for sure for real estate agents is just kind of walk you through how to do it so that you don't have to pay me to do it, and just give you the link. Okay, here's the website with the state of Texas that you can go file it on. Here's the form that you need to file. Here's the sample operating agreement that you're going to need whenever you go create a bank account after you get the LLC formed. And so I just walk agents through that. I don't charge them to do that. If somebody was like, hey, look, I want you to do it for me, Sean, and then I'm spending 3, 4, 5, 6 hours doing it, well, then obviously that's a different story. But I'd say I'd say probably 9 out of 10 clients of mine, real estate agents, developers, builders, anybody that once comes to me for corporate legal work, creates it themselves, because I just show them how to do it. They come to me for the more complex documents like an operating agreement, resolutions, and things like that. But the creation of the entity itself is super easy online. So yes, I can help do that. I got a question in the chat that says, how do we structure the business when filing the LLC? I think what that means, if I'm interpreting that correctly, for the person that asked it, if you can message me again if I'm not interpreting it correctly, since it was a direct message. How do you structure the business when filing the LLC? It's you created it just like you do any other business, right? So if I am a real estate agent and I want to create an LLC, I'm going to go on the state's website. I'm going to file the LLC. As by myself. I'm going to pick up an address, right? So you have to have an initial mailing address or a principal office address, which for a lot of people is usually like their home address, which you can use. And then if it's just a single member LLC, you just put managing member, and then you just create it. And it's that simple. You just create the LLC. You do have to tell your broker. So you tell your broker, hey, look, I've got this LLC that I've created. Send the corporate documents to your broker. Your broker will register that LLC with Trek. Not a hard process at all, because it was made a lot easier on January 1st, 2024. They'll register that, and then you can just get paid to the LLC. So as a real estate agent, it's no different than forming an LLC for a random person that comes to me that wants to start a dry cleaners. So it's the same way. You just decide who's going to be the owner of the LLC. You decide what the principal address is going to be, and you file. So that individual that asked me, Greg, messaged me. I can help you or guide you through that if you want to email me.
Match to the
How do I mute whoever's talking? Okay. Does anybody else have any other questions about anything at all that Sean talked about, or even that he didn't talk about?
I have a lot of questions, but I don't want to be overwhelming.
Yeah, you won't overwhelm me. Far away.
Okay. So let's start. Okay. Should you wait until you got like a certain amount of money rolling in before starting an LLC? And what's the good tax benefits behind starting an LLC?
I don't want to look. There's a tax side of that question, and there's the legal side of that question. From the liability perspective, I don't think it matters, or it shouldn't matter. If your goal is to protect yourself liability wise, the amount of money that you're bringing in should be irrelevant. Whether you make $1 or $5,000 or $250,000, it doesn't matter as far as the liability protection. From the tax perspective, again, I'm not a CPA. I'm just telling you this because I have owned several LLCs, and this is just Sean's personal experience. It's not my tax advice. From a tax perspective, there is a benefit to the LLC once you've created it. Once you get above that Social Security wage-based threshold, which is I think $126,000 right now per year in revenue. So once you're above that is when you can start taking sort of these tax-free distros, for lack of a better word. So there is a tax benefit there. But as far as the liability protection, I wouldn't sit back and wait. I wouldn't sit back and wait just because of the taxes. I would be proactive about creating it from a liability perspective. You should talk to a CPA to find out whether or not tax-wise the structure is good for you. Whether you want to file an LLC with an S corp tax election, because an S corp tax election has different tax benefits than just a regular LLC that's treated as a disregarded entity. So I would talk to a CPA first to figure out LLCs I'm a big fan of, but find out whether you want to be a disregarded entity or an S corporation, which is part of that LLC. So, but I think the sooner you get started with it, the better. And then you can start writing stuff off. You can write stuff off. I mean, I write everything off.
So can you, I'm sorry, I think, so if you just file as like a 1099, do you still have the option to write things off, or can you only write things off after establishing an LLC?
Well, a 1099, again, I'm not a CPA, but a 1099 is for independent contractors. So a 1099, if you had an LLC, you wouldn't need a 1099. As a 1099 employee, self-employed effectively, you can write stuff off. And the same holds true as a company, right? So if I'm an LLC and I have $5,000 in marketing expenses, I can still write that off. You would want to, when you talk to a CPA, you'd want to tell them what you're maybe, like, let's say whatever you made last year. You would tell the CPA, this is what I made last year. I'm thinking about filing an LLC. What are the ramifications for me staying at 1099 versus filing an LLC? What are the tax consequences or the tax differences between the two? And if there's a difference financially, like a big difference financially on taxes, then you have to decide whether the liability protection is worth it or not. Like if the LLC is a higher tax burden that you have to pay versus a 1099, you may hold off on that LLC for a while. But for every person I talk to, I always tell them start with a CPA first, figure out what the tax consequences are, and then decide whether you're going to create the entity or not.
Okay. Thank you for that. CPA. Okay, I'm sorry. I have one last one, but it's kind of a weird question. I just kind of always want. So if I started my business in January and then created this LLC in, I don't know, say June, right? And then, you file your taxes for that previous year. Would I be able to claim everything for that whole year? Or could I only start claiming that I
Like if you, how would that, again, not a CPA, that is a CPA question, but as far as the tax benefits, I don't really think it should matter a whole lot, but the expenses that are part of the LLC, you can't write anything off really that's not, if you don't have the LLC in, January, then you can't write stuff off or treat it as an expense for the LLC when the LLC is not created until June. So, tax wise, fundamentally, it may not be that much different, but it could be, right? Because if I create an LLC in June and I just freaking murder it on revenue from June to the end of the year, but all my expenses were prior to the creation of the LLC, then I don't have a whole lot of expenses to write off that taxable income, i.e. revenue that I've generated from June to the end of the year. So it probably would make a difference depending on how much revenue you make, what the taxable income looks like. When do you spend the money? When are your expenses incurred? So I think it could make a difference from a tax perspective.
Okay, cool. Thank you.
Yeah, that was supposed to overwhelm me.
Well, honestly, I do have one more.
No, just fire away.
Ask Diane.
Come on, just give it to me.
Okay. This is kind of like, I guess, out of context, but for like a long-term goal of mine, I've always wanted to become an investor. So whenever it comes to that point, should I leave my real estate business in its own LLC and then start a different LLC as an investor standpoint, or would it be beneficial to merge them together?
Yeah, and that was a hell of a timing because Samuel just asked a very similar question that I can use to answer with the question you just asked, which Samuel said effectively the same thing. Can I have several different businesses under one LLC, which is essentially what you're asking too. I am a massive proponent of keeping businesses separate. So,
Okay.
and let me tell you why. Let's say, I'll use your example. So you've got your real estate business, okay, you're a real estate agent, and then you go create this investment company, right? You start flipping some houses. Well, what happens if it's all under one LLC and that house flipping business that you have, maybe there's an issue, a defect in one of the stairs after you rehab the house and somebody trips and they fall and they die in the house and they sue your ass for wrongful death because of a defective stair on a house that you flipped. I know that's morbid, okay, but this is where attorneys' minds go, okay? Let's say that happens. And your ass gets popped with a $5 million judgment for wrongful death. Well, because it was all in one LLC, that judgment isn't just against the house flipping business, it's against any real estate or income generated by your real estate practice. And so that's why I fundamentally believe you have to keep businesses separate. So your flipping business, that's one business. Your real estate business, that's another business. And that goes to Samuel's question too. Can I have several different businesses under one LLC? Hell no, in my opinion. I mean, you just don't do that because if I have one business over here that gets sued and loses, they can come after this business over here because why? They were under one LLC. And so you keep industry separate, keep businesses separate. I just cannot stress that enough. I'm going to take your question one step further. Let me make sure I didn't miss anything. I'm going to take your question one step further, which is like, let's say you're flipping houses and you have, let's call it five properties that you're now flipping at the same time. How many properties is too many in one LLC? And there's a varying schools of thought out there about that. I like to keep properties separate. So, if you have a rental property or you have a flip property, if flip properties, if you're in and out relatively quickly, month, 2 months, 3 months, okay, fine. You can do them as all, as part of one LLC. But if you're buying properties and you're buying them, you're rehabbing them and you're holding them and you're renting them out, and you've got 5, you've got, let's call it 10, you've got 10 rental properties, you really don't want 10 rental properties in one LLC, because that same morbid example I gave you a second ago, somebody comes over, one of the rental properties has a pool, one of the kids goes swimming, the kid drowns in the pool, they sue you for negligence, and now you get a judgment against you for a thing that happened on one property. They can come after the assets that are held by the LLC for all other 9 properties. And so for rental properties, I think separating them out is a very important thing to do, either through separate LLCs or what we call a series LLC. I don't want to go down that rabbit hole because it's complicated. But I think having separate entities or separate companies for rental properties is important. For rehabbing properties or flipping properties or investments in properties that you're turning around and you're selling relatively soon or quick after that, I don't think it's necessarily as important to have multiple LLCs for properties that you're only holding for a relatively quick time.
No,
So
that makes
I have an additional question because I've worked with a lot of investors. So they have like their LLC of like whatever it is that their company's name is, and then they buy a house. Would you recommend like, so you have like your investor LLC company, but would you also recommend like opening an LLC for 123 Blue Jay Drive and then 2408 Flagler Street? Like, would you like,
Yeah, I mean,
if there, I mean, I know it depends on if you're buying or holding or flipping, but like say you're flipping houses, would you also buy it with like a new LLC for that specific house?
I think you could. I would say that I would say for investors that flip, they generally don't separate out the LLCs with the properties out with different LLCs. For investors that hold them, yes. And what a lot of times they'll do, well, some of them will do, is they'll create sort of this master LLC. So like, let's say you got the masters up here, one LLC, and then you've got little LLCs off of it. We call that a series LLC. So 1, 2, 3. Here's the master. 1, 2, 3 Main Street, 4, 5, 6 Main Street, 7, 8, 9 Main Street, and they're all different little sub LLCs. That's a series LLC under one LLC, which is the master. So there are investors that do that for properties that they hold or that they rent out. For investors that flip, they usually don't do it that way, but some do. Some do it that way. Man, what the hell? Siri's done got me on my cell phone. I don't know how to use Siri. This is the wildest thing. I mean, I'm just not very tech savvy. So I don't know even how Siri got on. Oh, I probably said series and they thought I said Siri. That makes sense. But investors will buy properties in LLCs, separate LLCs, and then they'll still flip them. I would just say it depends on the number of ones that they're doing, what's their exit strategy, how long are they going to hold it, how much money are they putting in, where's the capital coming from? Because that's a big piece of this. I have investors, I represent a lot of developers and investors that are pulling capital from other places. So like they've got, family friends that are investing in this rehab project on university, or they've got, maybe they've got investors from India or China or wherever overseas that are investing capital into some of these different projects. And when you do it that way, then yeah, you're creating different companies for every single one of them because there's different investors involved in each one of those. So if you have different investors, for sure, you're creating different companies. But the average investor just usually flips it, doesn't stay in it very long, and just uses the same LLC.
Okay.
I got a question in the chat. It was just direct to me, but was a question about, like, let's say you started an LLC, created an LLC for one particular purpose, and then whatever reason you didn't pursue that LLC for that particular purpose. Can you use that LLC that's already filed with the state of Texas for your real estate, or can you use it for anything? And the answer is yes, provided that the certificate of formation you filed with the state of Texas does not limit the activities or the type of business. If I created a company and said the purposes of this business are to transact business in Texas as a retail boutique, if I put that, then the business has to be limited to a retail boutique. But when I create companies, what I do is just more vague, which is all that's required. This limited liability company is created to conduct business in the state of Texas. Boom, whatever, it's vague, right? I can do whatever business I want with it. So if it has that language, that broad language, then you can use an LLC that was created for some other purpose. You can use it for whatever purpose you want now. You're not limited to the reason that you created it.
I have another question. So this is more so on like a leasing standpoint. This could be residential leases, commercial leases, I'm assuming, and also apartment locating. So what kind of trouble can you get into if your client feels like you're only showing them properties that are paying a high commission? Because with residential, you don't come across that as often, but in leasing, it's always like that, no matter if it's residential or apartment locating.
Yeah, that's a good one, and that really ties in really well to the NAR settlement and the NAR litigation, because there's just, and this is why I think there's going to be an increase in the number of agents that get sued, because that is just a textbook example of steering, right? So one, it's example of steering for one, and two, it could be considered a breach of fiduciary duty. And so where Jordan's going with that is, where I think she's going with this is that as a real estate agent, your obligation and your duty is to your client, and it doesn't matter whether they want to go see some not nice property or apartment, okay, or they want to go see some house that's paying 1%, or they don't want to go, they want to go to this, they want to go check out this apartment, but it's only paying $500, right? Your obligation as an agent, as you guys know, is to take them, right? I mean, that's your obligation, and so you can't steer them away from it, and you can't not send them what you think is in their best interest just because the commission is not what you want it to be. What I would do as a real estate agent, and I don't envy you guys, I think you guys have one of the hardest jobs in the world, but what I would do as a real estate agent is this, especially if I have like a buyer's rep agreement signed or a tenant rep agreement signed, and it maybe, let's just call it 3% in there. I know commissions are negotiable, but let's just call it 3%. And I'll play it out on the purchase side. And I'm a buyer's agent, and I'm looking at properties, and I see this freaking just killer property, and I'm like, my client would love this. Like, this is it. This is it, right? Oh shoot. They're only offering 1% commission. The seller via seller credit's only offering 1% commission. So now as the agent, seller's going to pay 1%. Well, who's paying the 2? Because you had a buyer's rep agreement signed at 3. Well, the buyer's paying the 2, right? So the call that you need to make is to your client. You call your buyer, and the similar analogy ties into leasing too. You call your buyer and you say, hey, look, I found this property. It's kick-ass. I think you're going to like it. I've contacted them. The listing agent has told me that the seller's only offering a 1% credit for 1% of the real estate commission. We signed. You and we signed an agreement that says 3%. That means you're on the hook for 2%. Do you want to see that property knowing that you have to pay the 2%? Obviously, I'm pretty upfront. You got to make it a little softer than that, okay? Like, yeah, I mean, customer service, right? But they're either going to say, yes, I want to see it, in which case you have to show them, or they're going to say, no, I don't want to see it because I don't want to pay the 2%. Either way, you want to get that in writing. So if they instruct you, I don't want to see that house because I'm going to have to pay the 2%, get that in writing. Because if you don't get that in writing and you don't take them to see that house, and they sue you for breach of fiduciary duty because you didn't take them to see that house because you put your interest above theirs because it wasn't paying a full 3% commission, you're going to lose that lawsuit. And you're going to lose that truck complaint. So both purchase side, lease side, it's always very, very important to document. It's going to be more important now than ever to document those conversations, document it in writing, That's how I would do it if I was an agent. I'd say, hey, look, we signed this agreement. I'm willing to work with you on it, but this is where the 2% would have to come from. And I bet I would have ventured to guess that a lot of buyers are going to go, yeah, I don't want to see that, or hey, can you, I'll pay you 1%. Can we revise the buyer's rep agreement, to 2% total versus 3? Okay, fine, whatever. But those are conversations that are going to have to be had.
So I actually sorry, I'm like always the person with the questions, but I think my questions could be helpful. So, so in leasing, apartment leasing, most of the time, I don't really know any apartment locators who get buyer's rep agreements for apartment locating. So obviously a buyer's rep agreement doesn't necessarily outline how the apartment locating industry works. It does for like residential leases, but would you recommend, could we have like an attorney create some sort of a rep agreement that is very focused on apartment leasing? Because what happens, I feel like what happens a lot with leasing is you either have a client that's working with like 5 different locators, and if maybe they had something in place, they would feel a little bit more obligated. But also I think too, like in our industry, the softwares that we use for apartment locating, a lot of times they won't even show us properties that don't pay locators. So we could be on accident not telling a client about a property because our software doesn't show it. So I'm just thinking, like, would it be beneficial for us to have our own form of like a buyer's rep agreement for locating?
Yeah, I mean, I think, the attorney in me obviously is like, well, hell yeah. I mean, the more document if you get an agreement that's signed, well, the agreement's enforceable. There's part of me that is a little bit cautious about doing something like that right now in this current landscape that we're in of the litigation, the public eye being all over real estate commissions, albeit purchase, sale, leasing. I mean, it's a weird time right now. Could we create some? Yeah, I mean, I think I probably drafted one already, but yeah, I mean, absolutely. Is practically now the time to do it? I don't know. I mean, that's a business decision really to be made. Do you want to be one of the ones that's out on the forefront, making people sign these agreements? I just don't know whether that's a good thing to do right now or not. But yeah, I mean, to answer your question, I mean, sure, no problem. I mean, you could certainly have an agreement, and I think agreements are really important. I don't know. I mean, I guess if the apartment complexes, I don't know if they'd sign them, but I mean.
Well, I mean, more so with
your
client.
buyer, yeah. I mean, yeah. I mean, absolutely, they could sign. I guess maybe now I'm wondering whether the prospective tenant would sign them. I don't know, but yes, you could absolutely have an agreement drafted to that effect, and a lot of states do that. So.
And so you can't get in trouble for steering if you didn't, like our systems that don't show us properties that don't work with real estate agents, like they intentionally don't send them to us.
If you don't have access to the information, then I mean, how else are you gonna? I don't know enough about your systems, but if you don't have access to the information, how are you gonna take your client to it? So I don't think that would be a situation where you can get in trouble.
Okay, yeah, because we have that happen. Like clients will come to us and be like, "Well, I actually found this property," and then we go and look, and we're like, "Oh, well, the reason why we don't know about that property is because they don't pay locators, and our smart apartment data doesn't show us properties that don't pay locators." So it's like we feel. I know for me personally, I know Kelly, it's like kind of awkward because it's like we didn't intentionally not send it to you, we just weren't told about it.
I mean, but if they want to pay, that would be kind of awkward, but at the same time, like, why am I going to show you a property that doesn't pay? Right. So, I don't think that would be a breach of duty, but I do think an agreement would be a beneficial thing in that instance, where if they're not paying and they want to go see another property, somebody's got to pay you.
Mm-hmm. Yeah.
Yeah,
Okay,
I saw that a comment in there about EXP requires using a rep tenant agreement, and I did know that EXP does require that. Certain brokerages do.
for apartment leasing.
I don't know about apartment leasing, but I do know that they require it. I would, yeah. She's just said yes.
What other questions are in here?
Let's see. Client leases. I think Kelly hit one of these.
Yeah, those are more specific to apartment locating and getting like lease verifications back, which is the properties signing that they agree to pay us like X amount.
Okay.
Because they'll change their commissions anytime, but if you have the lease verification, then they've agreed to pay you that. But if you don't have it, then if they were paying 100% a month ago, but your client moves in 60 days or later, and then you're like sending an invoice and they've already changed their commission to 50%, you're getting 50%.
Mm.
So,
So
yeah.
it's always good for the documentation, like Sean was saying. Like, I
Yeah.
know as soon as our client says that they've applied somewhere, I'm like harassing that on-site team to send me something in writing about what their commission structure is. Because I have worked on-site and I know that a regional manager could call at any time and say, you know what, y'all got 5 leases today. We're no longer paying 150%. So yeah, definitely, like Sean was saying, like get everything in writing, like all of it. But cool. Well, if any last questions? I know we've been on here for about an hour. Sean is super busy today, so we appreciate his time. But anybody else have any additional questions? We will be sending out this recording as well and Sean's info.
Yeah, if it's helpful, if you guys want to do this every month, I'm down to do it every month.
Yeah, no, it would be great. I think there's a lot of questions in the leasing field that we just, I don't know, people are always talking about sales. They're not ever talking about like residential leases or apartment locating. So there's definitely space for it. So.
I mean, there's an apartment locating right now, I think more than ever. It's got to be a good moneymaker. I mean, yes, it might be a pain in the ass to collect, but I mean, it's got to be a pretty good business right now. I just can't imagine it's not because people aren't buying as much.
Well, people aren't buying as much, and something we're personally seeing, just being people that are in like owning a brokerage, a lot of residential agents are freaking out about the settlement. So they're like making their license is inactive, or they're like, I just want to do apartment locating. Like a lot of people are just freaking out, which is understandable. But
I mean, it's understandable, but the industry's, I mean, that's why I try to give a little perspective. Like, people have been attacking commissions for over 40 years. I mean, it's just what happens. And I think, the agents like you guys that are taking the time to really be involved, invested in this and learn and grow and adapt. I mean, you guys you're gonna take all the business from these other yahoos that aren't doing that. So for people like everybody on this call that's passionate about it, you're gonna come out making more money. So not that money is the end all be all, but I mean, kind of nice to have some money. So I mean, this is a good time for you guys to be doing this, and I appreciate the opportunity to get on.
yes, definitely. I think one other thing that I think might be interesting. So Shalante said that like it took 8 months to get paid from an apartment complex. Say, this is just me like being nosy and curious. Say there was a check out there that we wanted to say, hey, I'm filing a small claims court like lawsuit. Say I wanted to do that. Could I be like, I want to charge additional money on what I'm not only suing for like the commission, but I'm suing for the 10 months it took me to collect on this.
Can you get like interest and shit on it?
Yes, because we pay invoicing people. So I mean, if it took our invoicing people $5,000 worth of time to collect on something, like could we?
I mean, maybe you could get, if you could prove economic damages that are reasonable, you might be able to obtain those. The problem with JP Court, and I mean this with the utmost respect to JP Court judges, is that they're not usually lawyers, and they usually don't have any legal experience. They're just elected officials. Long story short, my first trial I ever had 15 years ago was down in the valley, and I went in. I thought I was kind of hot stuff, and I went in with this custom suit, and this judge goes, "I don't like the way you look, Mr. Clemmensen," and I lost in 30 seconds. So the reason I tell you that story is because there's really no whole lot of legal justification that goes behind some of the rulings. So you have to be careful when you sue in JP court. I think you probably could try to articulate a claim for economic damages. I'm just not sure a JP court judge is going to understand that argument and buy it, to be honest. But
Gotcha. That makes sense.
it's like Judge Judy, but Judge Judy's actually an attorney.
Awesome. Well, cool. I don't have any other questions. I definitely am very open to wanting to do this like again. Somebody, Cheyenne.
After establishing a series LLC, could you group them all to be owned by a trust instead of you personally? A trust can own an LLC instead of personally. The benefit to the trust owning the LLC would be from an estate planning perspective. Now, I'm not an estate planning attorney, but a trust that owns an LLC, like if I personally own an LLC and I pass away, then my will would govern the disposition of whatever assets are held by that LLC. If the trust owns the LLC, then I don't have to go through a probate administration. So, Cheyenne, that a trust is beneficial from that perspective, an estate planning perspective. It doesn't change anything from a liability perspective. It doesn't change anything from a tax perspective. But then you tell your other point, you used that trust as a personal bank to borrow against future investments. Yeah, I mean, a trust can be a bank or a lender, so to speak, that you can use to borrow against. And then a lot of wealthy people do this, where they then have this trust serve as a bank or a lender to show debt. And they do that to try to benefit themselves from a tax perspective. So yeah, I mean, to answer your question, you could do both of those.
Okay. Sorry, I was just picking your brain.
No, it's all good. That's a good question. That was a good one. I like that one.
So, well, thank you for that.
Yeah, of course.
All right. Well, thank you so much. We'll be sending this recording out in Sean's info, and hopefully we'll put another one of these on the schedule. So thank you so much for your time, Sean.
Awesome.
Yes,
Good to see you guys.
thank you.